Okay, next case on our docket, case number 18-3186, VIKRAM Inc. versus COMPU-CLINIC Corp. and Four Seasons Roofing, LLC. My old staff attorney there. Counsel, whenever you're ready, fire away. Judge Cohen will get a self-defense instruction up here then.
May it please the court. Good morning. 5 minutes is fine for rebuttal.
Very well, thank you.
Good morning. My name is Tim Moorhead. I represent VIKRAM Inc., my co-counsel Muriel Whitehead, also to my left. This case, I asked for oral argument about this case because it presents, in my mind at least, an important extension and corollary to the case law that we see with regard to spoliation of evidence. In the case, we assigned 4 different issues about error. 2 of them are inextricably entwined in this error about spoliation. So as that, in my mind, is one of the most interesting and important items of the case for clarification through the court, I'd like to address that first.
What issue is entwined, using your term, with spoliation?
The spoliation of evidence is entwined with the hearsay issue that is the 4th item.
The list.
The list. Because the list comes from the spoliated evidence, totally.
I want to make sure I understand. Mr. Gross sent the list or a copy of the list to your client according to his testimony within like 10 days or less of the event, correct?
Close to the term of the event, yes. And
he claims that the insurance agent or claims adjuster came out, looked at it, and said, "You can, now that I've looked at everything, you can do whatever you want to with those computers and equipment." I mean, assume that was evidence that was presented.
He says that, and that created a big problem, because the whole issue about whether insurance is in play couldn't come before the jury, but he was allowed to testify that Sid Friedman, who was not identified as an insurance adjuster, I believe.
Just like as an agent or something?
He tried to say he was their agent of some sort, but he...
But to follow up on that, so I mean, this is evidence presented. There's no letter from the landlord or the insurance company, a preservation of evidence letter, which
Correct.
Nowadays is relatively common if somebody wants to keep the evidence.
Dealing with a defendant.
And the request
Correct.
for production was for documents, not for the computers or equipment themselves. That kind of bothers me. I mean, I understand the spoliation. It concerns me that somebody's suing over damaged goods and doesn't keep the damaged goods for trial. That's a problem.
Right.
But when you don't really ask for them to keep it, you don't ask to see them, and your insurance adjuster has already seen them and said, do what you want with them. I mean, we're kind of teetering here a little bit. It doesn't seem to me we're leaning so strongly in your favor as you might hope we are. So with that background,
Sure.
Take your best shot.
So let's start with Mr. Friedman. Mr. Friedman is an insurance adjuster, true. He went out to the site, true. His testimony...
But he's your insurance adjuster.
He is the insurance, correct. He is our insurance adjuster, correct. But his testimony, which because he's the insurance adjuster, we can't get into in front of the jury.
You could, but you
about
didn't want
the
to.
Insurance. Well, if I wanted to waive that, that's right.
Right, I'm saying.
That's right. I could have put him in there and had
Nobody
him
faults you for not bringing up insurance.
Okay. So, and this is why it's so interesting and how it plays into Torres and Reed. Okay. So if we look at that portion of the evidence, okay, so we have a plaintiff, and true, when you are going to be a plaintiff in an action and you want a defendant to maintain evidence, you send your letter, hold on to the evidence. It's also important to send those if you're
Any
going to.
party who wants the evidence preserved does that. It's not a plaintiff, it's not just the plaintiff, you know, it can be anyone who wants that evidence. If you're making a claim of spoliation, or you're making a claim that this evidence is important, how long does it take to write a letter saying, we want you to preserve the evidence so that it can be further examined? It takes you 5 minutes to write that letter, and yet no one did that. The spoliation claim gets raised how long after the incident? How many years?
Once we find out that he spoliated it, was in 2016 when we were finally able to take his deposition.
But you're.
That's when it arose.
But your guy had been out and looked at it and knew of its existence well before that. The adjuster for the insurance company. He's aware of, he's gone out, he's looked at it. If your client felt it was important to maintain that evidence, then at that point, they send a letter saying, we want this evidence maintained.
I don't disagree
more than that,
he can send that. There's no doubt about that. But then when we talk about the cases that get into this, there's a difference drawn between a couple of different things. People who are presenting a claim affirmatively for spoliation of evidence, saying, I'm suing you because you got rid of my stuff and then I can't sue over here for it. There's a 6-point test for that.
But as to the you're concerned about getting insurance brought into the trial, and I get that, but the insurance adjuster may not be a computer guy or gal. The insurance company could have hired their own computer expert to evaluate this damages, and then that defense expert could have come in who's seen the computers and testified that, no, they're not $45,000, they're a pile of junk, they're computers from 1964, and they're not worth anything. And so, to me, it's kind of a red herring to say, well, our insurance guy came out and looked at it promptly, but we can't talk about insurance at the trial. Granted, I used to be an insurance defense attorney. But that being said, there's ways to have avoided bringing insurance in, but to have had your side's own expert look at that, evaluate the computers, come up with a value, and be able to testify at trial about what he or she saw as to the condition of the computers, right?
Right. There would be Mr. Friedman's testimony under oath, because his deposition was taken, is directly contrary to what is advanced by the plaintiff at trial. The issue was there was already an order, but because of motions in limine, that we could not get into the evidence, the insurance issue, period. So where this goes, if you will, if we look at Torres and we look at Reed, we're dealing with two places where the plaintiff inadvertently lost the evidence, whether they give it to their attorney and the attorney throws it out, or whether their expert has it and he gets rid of it.
Is there a timing issue in those cases that's different than your case?
Well,
again, when somebody inadvertently gets rid of stuff before your opponent has a chance to look at it, we get it. Here, it seems like your client was put on notice quickly that we're claiming all these computers got damaged. Here's the list, the serial numbers and the values and the customers' names, all the rest of that. Whether it's your insurance company or your clients personally want to go out and dispute that, you're on notice within a week or 10 days that the computers are a big deal.
Correct.
And yet nobody tries to look at them until after they hear in 2016 from Mr. Gross that he doesn't have them anymore.
Right.
That's the first time anybody wants to look at them other than Mr. Friedman.
Well, I don't necessarily agree with that point. First of all, the duty arises that we read in the cases. The duty says if you know that there's likely to be litigation, a duty arises. Being involved in the litigation, a duty arises. So that happened when they filed the lawsuit, and that duty arose, and they still had it, was the big item. Next, I send discovery asking for all of the documentation dealing with their damages, which is exactly what this list becomes. And I ask for documentation about the disposition of the equipment. Where's the equipment so we can come see it? That's in October of 2014. Now, it takes 3 months for the plaintiff to, after we've moved to compel, answer saying, we've given you everything. And then it takes another year for us to get his deposition where he says, I destroyed it in 2015. After the lawsuit's filed, after I've asked for requests for production for these documents, the tickets that are on them, if you're familiar with that is, instead of producing them, he destroys them. He had them in 2014 when I asked for them. He destroyed it in 2015 after I asked for it.
You asked for documents. That would be the tickets. I get
Right.
that. And if that's destroyed, that's fine.
Shredded.
It didn't really seem to me the tickets were that big a deal unless you're trying to find the customers. Did you ever send interrogatories asking what are the customers' names, addresses?
We went through replete discovery trying to find out who these people are. The problem is that the list would have a last name only. In many instances, it didn't have any name at all, which would have been on the tickets. The tickets also say, why is this piece of equipment in the shop? Does it work? Does it not work? Did I drop it in the pool? Am I here for an upgrade? That kind of thing. All of that information we lost, save one. There was one ticket, and this is what alerted us to the fact that there were tickets. That was Miss Villa's item, and Miss Villa's item said, won't power up. That's exactly the test that the plaintiff used to determine whether the equipment had been damaged by the water event. He said if it wouldn't power up, then I put it on the list as being damaged by the water. Well, he rendered irrefutable his testimony when he destroyed the tickets after I asked for them, and he destroyed the equipment after he knows it's relevant to his very own lawsuit. And again, that's what makes it so interesting about going from Torres to Reed and reading Judge Griffin's dissent in Torres, where she says, had this destruction not been inadvertent, I would be in the majority. And then Reed, where she writes for the court, then says, well, there's a way to level this field, and when there's been spoliation, we should do what we can to level the field. Dismissal was too much there. In the Reed case, the expert could opine based upon the detailed photographs that he had taken of the evidence in that case. No detailed photographs in this case. Nothing other than Mr. Gross saying, I looked at it, I wrote down things from the tickets, I then looked at the equipment. If it plugged in and powered up, then it's good. If it doesn't, then it's damaged by water. And here's my evaluation of the cost of it that I get from the internet, which is a whole other hearsay problem. So the spoliation becomes the list is the problem. The list becomes irrefutable by the actions of Mr. Gross himself.
So what was the sanction you were asking the judge to do?
The original sanction for, there were more than one motions that we filed. We addressed this when it first arose. Judge Orfinger sat in on that motion, which was for the action for sanctions and spoliation. We wanted to prevent the entry of the list and the testimony.
Is there any possible way we can reverse Orfinger on something?
Was it?
Actually, I have to say he was right in his order. I'm sorry about that, but when you read Reed, the difference is that at Reed, the discovery has closed. So were I sitting as Judge Orfinger and I'm looking at my own motion, having looked at his ruling, if he knows about Reed, he could reasonably say, well, discovery's not closed. They may come up with some other evidence. They may come up with detailed photographs. They may find the tickets for all I know, but discovery's not closed yet. But once discovery closes, the motions are re-upped again before trial. Now we know who's going to testify. They know what they're going to say. We know the limitations of the evidence. There's no doubt the three-pronged test for spoliation is met. It existed. It got spoliated. It's important to the case. Motive or fault doesn't come into that. Fault comes into the next stage, which is what is the remedy? How do we level it? That's Reed. So Reed talks about inadvertence. Other districts have talked and imposed sanctions where it's not inadvertent. striking pleadings, it's dismissing cases, et cetera, et cetera, et cetera.
But here
A more
again,
harsh sanction.
going back to what my first questions to you were, you've kind of got permission to get rid of it from your agent.
Who says the insurance company is my agent? I'm VIKRAM. He's not my agent. He could at that point have, they may have denied coverage
Well,
at that point.
I'm not saying he's bound by it, but this is not, from COMPU-CLINIC's perspective, the insurance company, your client says, my insurance company's going to take care of this claim. Great, I talked to your insurance guy, he looks at everything, well, what do I do with all this garbage here? You do whatever you want to with it. Well, you say he's going to take care of it, I talked to him, he says I can throw it away. What do I have to do? Do I have to come back around and ask you again, did you really mean he's going to take care of it?
Once you realize that it's important material evidence in a lawsuit, you have to maintain it. That's the law. Once I asked for it in discovery, the case law is fairly clear.
You asked for the, I agree, you asked for the
He
tickets.
had not destroyed it.
I agree you asked for the tickets, but you didn't ask for the equipment itself.
He had not destroyed it in reliance upon the statements of Mr. Friedman. He maintained it through 2013, through 2014. Now, the lawsuit is now filed. I've now sent discovery.
You never asked for it, so what do I need to keep all this junky stuff around here? I don't have room for good stuff.
I asked for the beginning of that in October 31st, 2014, when they existed. And instead of producing them, he destroyed them. With regard to discovery, discovery was open throughout the entire portion of the case. If he had destroyed it back at that time and said, oh, I relied on Mr. Friedman, that's a different case. He didn't rely on that. He maintained it all the way into 2015. And once that we've started discovery, just one production doesn't a lawsuit make. They lead us to the next things and lead us to the next things. During
Talk about the
discovery.
hearsay stuff real quick, or do you want to wait and?
I have
You're in
3.5
rebuttal.
minutes. I'll just say briefly on hearsay, the court let the plaintiff publish the hearsay list, saying that it was recorded recollection under 90.803 sub 5. If you read that entire statute, it simply says, you don't testify from the list until it's in evidence, till it's been admitted. He testified before it was admitted, and much like a math problem, these mistakes propagate as they go along. He would have never done that had it been sanctioned. I see that I have 3.5 minutes or thereabouts.
thank you.
Thank you. Thank you.
Morning, Your Honors.
Morning.
My name is Jared DePaula. I'm here on behalf of,
So your name is what, Jerry, what?
sorry?
I couldn't hear your name.
I'm sorry, Jarrett DePaula, on behalf of COMPU-CLINIC. As the court pointed out with regard to the spoliation issue, well, first off, the argument that VIKRAM raised in its initial brief was that the court failed to impose any sanction on COMPU-CLINIC, not that whatever sanction was imposed was insufficient. And that's a different standard of review altogether, because whether or not, they argued that it was a de novo standard review because they didn't impose any sanctions when they should have, and in reality it's an abuse of discretion because the court has the discretion to impose sanctions. The court did in fact impose sanctions, and then in the reply brief they flipped the argument to say, well, now what we really mean is that those sanctions were insufficient. So the original argument fails because the court actually did sanction COMPU-CLINIC for spoliation of evidence by providing an adverse inference instruction to the jury. As the court pointed out,
Do you agree in terms of the spoliation that what you're really saying is not that the evidence wasn't material, not that it wasn't spoliated, and you're not claiming that that didn't hamper them in defending the claim? You're saying you didn't have a duty to keep it?
there's no duty, correct. That's one of the main issues with the spoliation issue.
When you're suing for damage to equipment, do you have any duty to keep it for any length of time?
Well, my understanding of the case law on the issue is that there's no common law duty to preserve. And then the duty arises either from contract, statute, or a discovery request.
I'm just saying, okay, if you file suit, claiming, and we'll just focus on my customers' computers were damaged.
Right.
And they go, great, let me see your customers' computers. And you go, we got rid of them already. We don't have anything. Do you really think you ought to get to go to a jury on that case? Or at that point, you're kind of done? I mean, on that claim.
I've seen commentary in concurring opinions to the effect that once you're in litigation, you should preserve evidence. I believe the main opinions say, you know, the three-pronged or the three situations in which a duty arise. And that's a discovery request after litigation's been initiated. So that kind of defeats the argument that, well, once you're in litigation, that's it. Because the third one is a discovery request in litigation. So that would nullify that.
My question is kind of, before you even get discovery, if you're seeking damages for destroyed property, are you saying it's okay if you throw it away? I mean, before you file suit, I've got all these,
Right.
assuming that that's what you did, and I'm not saying it is, if we had these damaged computers and you got rid of them all and they were crushed and everything so nobody could ever go back and look at them, if those were the facts, would you agree that you shouldn't be allowed to go to a jury on that case unless you had some other form of evidence?
Well, all that's required is that the opposing party have an opportunity to inspect and test it. And I believe that's set forth in the Landry case that we cited in our answer brief. So you don't have to have the evidence throughout the trial. The other side has to have the opportunity to inspect, and they did. And not only did they have the opportunity to inspect, they did in fact inspect through their agent, the insurance company, close to the time of the event, who, as the court pointed out, blessed the disposition of the equipment.
What
with
about the tickets?
the tickets?
Yeah, they made a specific request for production of the tickets, and then subsequently they're shredded.
Well, I would disagree that they made a specific request for the production of the tickets. I think the request that they're saying would have included the tickets is a request to the effect that produce all documents used to calculate your damages. And there's no values, there's no numbers, there's nothing, you know, when he made the list, he had all the equipment in front of him. He had all the computer equipment there when he calculated the damages, the values. That was done within days of the event. So the tickets, you know, were the tickets used to calculate damages? He had the equipment right there. All you need is the equipment. He did his online research to determine values, and he didn't have those documents.
He used the tickets to put names down and.
On his list.
Right, so.
Right.
He did use that information to come up with his damages in part, right?
Well, the names, okay, well, I guess to me, it's kind of a gray area. It's like, were the names used to calculate damages?
It was in the list, wasn't it?
The list.
We're in the list.
Right.
The list is the damages.
Well, I think what's used to calculate damages is the equipment itself, the condition it's in, and then the research he conducted to determine the value. That's calculating the damages. I don't know that the actual names in and of themselves lend to, oh, I use the names to calculate damages. So I don't know that there was a clear discovery request. When you read that request, produce all documents that were utilized to calculate your damages, and it's like, okay, well, I have this slip with the customer's name on it. So I don't know. You know, arguably, when I read that request, that if I'm Larry Gross and I read that request to produce, I'm not thinking tickets with names on it that identify the equipment, because, you know, like I said, he used the equipment itself and he conducted research. I think that's what he used to calculate damages.
Let's talk about the hearsay aspect of the list and whether, it seemed to me from looking at the transcript, it started out as though Mr. Gross was going to be using the list to refresh his recollection, because unless you've got a really outstanding memory, it would be hard to remember all the computers and the names and the serial numbers and the figures without looking at something.
Correct.
So it started out more as to refresh his recollection, but it quickly turned into past recollection recorded.
Yeah, well, it's actually a past recollection recorded from the prior trial. There were two trials. The first one was mistried, and it was a past recollection recorded in that trial, and then the trial court entered an order on VIKRAM's motion in limine seeking to exclude the list for failure to satisfy the requirements of a damages summary. And in that order, granting that motion in limine to exclude a summary, the court commented that the list is I believe the court commented that the Gross would be able to testify under the past recollection recorded exception. So we come into trial with that understanding that, and the court reiterated in those opening arguments that that's how we're going to do it again. And so there was commentary about 90.8035, past recollection recorded. He's going to be able to testify to that. But the objection that VIKRAM made throughout those opening arguments, there were motion and limine arguments is what they were. So, I mean, he wasn't just, in none of the 12 motion and limines that VIKRAM filed objected to the list as hearsay.
Well, the list included data pulled from websites, did it not?
The list included the damages value that Mr. Gross
Pulled from websites.
came up with from researching websites, yes.
And you think that's admissible?
Yes, because he is an expert. He had 30 years' experience in all phases of computers.
Expert, so he can rely upon websites and information off of websites? That's your argument?
Well, I believe he can rely on, I think he identified a couple of the websites that he went to, maybe Newegg, I don't recall specifically, but, you know, he had the equipment, he did some research to try to get a feel for what things were selling for on the internet. So it's not that he was going to the internet to say, what's the fair market value of this? Oh, here's an article that...
That is the definition of fair market value, isn't it? What a willing buyer will pay a willing seller.
Well, I think what he was doing was observing the open market on the internet, not researching an article that tells you what the fair market value is.
And you think that information's admissible?
I think the information of him going out to sample the market combined with his knowledge, I think that's admissible.
His opinions might be admissible, but the underlying data that's hearsay is not admissible, is it? I mean, that's the old expert
Yes.
can't be the conduit for inadmissible.
Right, he wouldn't bring in printouts of websites and offer that into evidence to show what they were selling.
Doesn't 8035 say that if it's a past recollection recorded, the document does not come in unless the other side offers it in evidence?
Correct.
And the other side here did not actually offer it in evidence. They opposed its introduction into evidence.
They did.
But the trial judge said, like, they virtually almost just as might as well have, I guess.
Correct. The judge, I think his words were that it was tantamount to the adverse party offering it into evidence, because they got into...
It's not actually offered into evidence. They opposed its introduction into evidence.
Correct.
So if you're relying on 803 sub 5, then isn't that a flag on the play, so to speak?
Shakespeare?
Well, so, yeah, if it just came in and that was it, correct, that would be it. That would be a flag against 98035.
Came in first by basically your guy reading it out loud.
And that's what, once you lay the predicate, it's okay to do that. But also, there was no objection as to hearsay when he was testifying from the list. The objection was, Your Honor, I raised what we previously discussed, my objection as we previously discussed, which was exclude the list as a sanction for spoliation during the motion and limine arguments. So he didn't stand up and say, objection, Your Honor, hearsay. He said, my previous objection, and that was a spoliation argument. So there was no contemporaneous objection as to hearsay when he read from the list. So that all came in as substantive. That came in unopposed. And then once we get to introducing the document on redirect, that's when they object as to hearsay specifically. And then there's two issues with that at that point. First off, it's cumulative to the evidence that's already appropriately come in. His expert testimony as to values, okay, that was appropriate in and of itself. And then also that his testimony came in unopposed. So now we've got the substantive evidence in the record, and the list is cumulative to it. And also, as far as the court's commentary that it was tantamount to the adverse party admitting in themselves, I think the issue there is more along the lines of opening the door, because, when it was used on direct, you just go through what's on the list.
They open the door if they're trying to vigorously cross a guy who just read, in essence, the list into evidence on direct, so now they're going to try to poke holes into it. And so by them doing that, by being diligent in cross-examination, they get their head handed to them saying, well, you really have talked about it a lot, so they might as well put it in evidence.
Well, I would agree with you there if they stuck to the list, but what happened was they started bringing up names that weren't on the list. and equipment that wasn't on the list, and then saying, hey, you know, you replaced equipment for Miss So-and-so, you know, why isn't she on the list? And it's like, well, her equipment wasn't damaged by the rain event. And this happened with a couple different names and a couple different pieces of equipment. So it started to...
the cross-examination is, why isn't your damage claim higher? Because you missed stuff?
Well, it started to, I think, confuse the damages, the testimony. So it's like, okay, now we're bringing up new names, new numbers, and we're mixing it in, and I think with that, you're kind of opening the door to say, okay, well, now we got to come back and clarify. We've got to come back and straighten out what you've just done by kind of going outside of the list and blending that with issues on the list. That's how I see the opening the door aspect of it. But also that the list, once it came in, was cumulative to properly admitted evidence. And
Isn't that somewhat analogous to saying in a personal injury case, when the CME doctor prepares his or her report and gets up and testify, that the CME report then should physically come into evidence too? Is that what you're kind of saying to me?
well, I think I cite a
That's
case.
usually the status of the law, isn't it?
I think the brief cites a case similar to that very proposition, the answer brief, and I'm just going to double check that.
Problem, I tried to do that. Wasn't a very good lawyer, I guess, back then.
So, yeah, so Bogdanon v. State, 763 Southern 2nd, 376, cited at page 40 of the answer brief. It says, holding that admission of hearsay medical records and battery prosecution was harmless error where they were cumulative of doctor's testimony.
Well, I think that's a distinction with a difference. I mean, if you're talking about the hospital records are admissible in evidence, the hospital records aren't created for the purpose of the litigation. I mean, the CME report is prepared for the purpose of litigation and doesn't come in. The doctor can testify about what he or she did in the evaluation,
But I think the underlying issue there is if evidence came in properly, okay, and the evidence didn't just come in as a 90.8035 past recollection recorded. That wasn't it came in unobjected to. So we've got the substantive evidence in the record. Okay, not...
But I thought you said, the judge already said, we're going to treat it as past recollection recorded, which is 90.8035. And there must be a reason for including in that subsection of the statute that the memorandum does not come in unless the opposing party offers it.
Correct.
Got to be a reason for it. They don't just
Right.
put stuff in. And
Right.
here, the opposing party did not offer it into evidence, right?
Correct.
That's,
The opposing party
seems
did-
to me to be a problem.
Right, right. And, you know, I guess in that regard, it was, the judge made the call that it was, that they were tantamount to offering it by the extent that they used it on cross.
Well, as tempting it is to write an opinion that says we're going to ignore the statute just to cheer up Judge Eisnagel, you know, that does seem to be a concern, doesn't it? I mean, why else would the plain language there be in the statute if we can simply say, well, seems like the statute was not complied with, but, you know, what the heck? They couldn't have meant everything. They couldn't have meant it that time they wrote that statute, right? In other words, isn't this a problem, echoing Judge Edwards' comment, that, you know, it says you can't do that, the
Right.
adverse party can do
Yeah,
that.
and
They apparently didn't want to do that because they objected to it. It came in anyways because the judge basically said, well, you sure talked about it a lot, so we might as well put it in evidence.
Right, right,
And
yeah.
that doesn't seem to be consistent with what the legislature thinks under that hearsay exception.
And
Right.
kind of going back to what Judge Lambert was asking about before, plenty of times you have cases where there's experts. The experts, sometimes they prepare reports, sometimes they don't, but the expert report is rarely admissible into evidence on behalf of the party who hired the expert. Again, if the opponent wants to get it in because it shows what a crummy job the expert did, that's one thing. That's their call. But you don't get to put your expert's report in, and that's basically what this is. You're claiming Mr. Gross is an expert, which probably he is. He got these values, all the rest of that, testified about them. That's fine. But then by having the thing in black and white so the jury can sit there and look and add it up and fill it out, I mean, that's what 8035 says you're not allowed to do.
Right, right. And so the only argument, I mean, I agree, Your Honor. So if there was just a straightforward, no, we couldn't submit the list into evidence ourselves. And it's the issues we've raised in the answer brief as far as why we believe that the trial court didn't err in admitting the list, and that being that it was cumulative to properly admitted evidence, expert testimony.
But it would always be cumulative under 8035.
Well, I think if they would have objected as to hearsay when Mr. Gross was began to testify from
You're
the
saying
list.
it was a proper exception to the hearsay rule under 8035. The judge ruled it was
Right.
proper under 8035.
He did.
And, you know, so they're agreeing with you, and shame on you for agreeing with me and the judge. I mean, 8035 applies or it doesn't. Seems like it does. It's a problem.
And that's like saying, well, the CME expert testified, and now we should be able to put in the report because it's cumulative to what he just testified, so it's no problem. Unless you have a case that says that, which I wish I'd have known 20 years ago, you know, I'd like to see that.
We're just going to rely on the cases cited in the page 40 of the answer brief on that issue as far as it being cumulative. Yeah, as far as it being cumulative.
20 years ago was when I was a lawyer. That was the 20-year reference.
You're still a lawyer.
You can't hold me to that. Am I supposed to have a bar number and everything? Jeez,
Paid bar dues.
look for that somewhere.
And then with regard to the other two issues, we talked about spoliation some, we talked about the hearsay issue. I just briefly comment on the other two issues in my last.
Let me ask about the bail amendment. I mean, they're complaining about the.
Right.
Did, at any point in time when your client was testifying about all the damages incurred by his clients or its clients, did they object, saying, well, wait a minute, you can't testify about somebody else's property?
No, right.
So the only objection as to bailment came up at the time of the charge conference when you wanted an instruction, and then they objected to your motion for leave to amend the pleadings to conform with the evidence.
Correct.
That's kind of untimely. If they would have objected early on to all that testimony, they'd have something better to talk about now, but they really don't, and the judge didn't abuse of discretion. Is that what you just said?
Correct. Right. That's one line of analysis.
Argument
Right.
there, all right.
Especially
That's a
since
good
it's
argument.
In paragraph 29 of your complaint, you say, as a direct result of VIKRAM's breach, you've incurred significant liability to customers who look to plaintiff to repair, replace, or pay for the computers.
Exactly. And so this
Saying it
isn't,
wasn't a big surprise that you were going to seek that at trial?
right, no, this was known
Have to
throughout.
move to amend to conform to the pleadings, because lo and behold, there it was.
Right, and I don't know that we needed to do that because it's not
Said
a.
you didn't. Yeah,
Sorry?
Your meter's running. You just said you're pretty good on that argument. What's your other argument?
Right, okay, and then the last argument had to do with, that was the bailment instruction, the denial of their motion for summary judgment to limit their liability under the lease
So how
term.
dare you people not have insurance to cover when their people leave a big hole in the roof?
Right, exactly.
How dare you?
Yeah, and, well, for one, they didn't raise that in their motion for new trial, so that issue is waived. The issue they raised in their motion for new trial is we should have been able to present this evidence at trial, which they actually themselves moved in limine to exclude.
Well, doesn't paragraph 8 of the lease talk about you need to get liability insurance to protect them, and then as extra rent, you have to pay for their insurance? It doesn't describe it.
Right.
But it can only be property and casualty insurance?
Correct. And then the insurance I see my time is up. Thank you,
Go
Your
ahead and
Honors.
finish your answer to Judge Edwards.
The only other comment I would make about the insurance is that the paragraph 8, I believe, that says what the tenant's insurance is supposed to be, applies to the tenant, to indemnify the landlord for the tenant's negligence. And that others is qualified by the tenant's others. It has to clearly state that the landlord's negligence would be indemnified, which it doesn't. And the harm wasn't caused by a catastrophe, it was caused by a roofer opening the roof up. Thank you, Your Honors.
Okey dokey, thank you.
Say okey-dokey.
In my best Judge Howard imitation, okey dokey, thank you.
Judge Edwards, you point out exactly the comment of Judge Harris in the Torres case. This can't be the law, that a plaintiff can destroy his own evidence and then come in and talk about it in court.
And I firmly believe that, but then again, you've got, the thing that bothers me is the timing in terms of when did y'all ever actually ask to look at the computers?
Right.
And the only time I really see you ever did was after you took Gross's deposition and you find out they're gone, then it's like, oh my God, we can't see him. And again, the other thing that bothers me, and I won't belabor it, is the insurance adjuster who your client said the insurance is going to take care of it, said you can get rid of them. But if you want to touch on, we've already discussed that, I think, ad nauseum. I don't know if you want to discuss something else.
Well,
Feel free.
the only point I want to make about that is the significance of that then litany of cases, which would be Torres, which was actually an issue about the Greco inference, to Reed, which says we fashion it's really entitlement is one test, and then fashioning a remedy is the second test. But those both involve inadvertent. And there are other cases that talk about when does this arise, this duty. And in my humble opinion, it seems to make a difference in who you are. If you're the plaintiff and you know it's important, you retain it.
I agree. I'm not at all disagreeing with that. Like I said, the permission thing
I understand.
is troubling.
I understand. I just want to mention briefly the Landry case was brought up by my esteemed opponent. In the Landry case, there was no spoliation in that. That had to do with an automobile, and the automobile had been sold, but it wasn't lost or destroyed. In fact, I think they found it later on. It had a title, and you could trace where it was. It's just that the particular person didn't have the vehicle. So let me bring this down to what we're asking this court to do, which is reverse and remand with instructions. And the instruction would be to remove the testimony and evidence that is the fruit of this spoliation, which is the list on its own. Forget the spoliation, is still hearsay and inadmissible. That's a de novo review by this court. And the testimony about it, which was specifically not supposed to come in under 803 sub 5, because it doesn't come in until the document's in evidence, and it can only be presented as evidence by me. So you can extract that from the facts of this case.
Couldn't they use the list to refresh Mr. Gross's recollection?
But they didn't. All they did was set it in front of him, and he testified to it. He read off of the list.
If you want us to remand it for a new trial, can't they just say, okay, we're not going to admit the document, but it's been a long time, and I need to look at this to refresh my recollection as to the damages? And they can use, seemed like I had an evidence teacher say you can use a ham sandwich to refresh your recollection.
But it doesn't come into evidence.
Right,
That's
I mean,
correct.
certainly, hopefully
That's,
we get a ham
they
sandwich.
probably could, and then we would try this for the third
Counsel for the
time.
appellee said, as he was basically reading the list,
You'd be
you did not
spoiling it.
object.
No, the court had already announced its ruling. Once the court's announced its ruling, it's not for me to
But the
continue.
objection you did raise referred back to, I'm reasserting my prior objection, and the prior objection seemed to be more, it shouldn't come in for spoliation reasons, rather than hearsay.
There were a multitude of motions in limine about that. I don't remember off the top of my head, but I believe hearsay was also raised. It also wasn't offered in evidence. The court had originally ruled this is not coming into evidence. And it didn't come in on direct, although they asked for it, because it's hearsay. It came in on redirect, saying that you heard that.
Okay, all right, thank you.
My time is up.
Yep, thank you, counsel, appreciate that.